often have you asked yourself whether you are processing personal data legitimately? For the processing of personal data to be legitimate under the Gibraltar GDPR, organizations must identify a lawful basis and be able to demonstrate said decision before processing personal data. There are 6 lawful bases, and these are outlined in Article 6 of the Gibraltar GDPR. Consent is only appropriate when individuals are offered real choice and control over how their information is used. Article 7 of the Gibraltar GDPR provides further detail on what constitutes valid consent. For example, consent must be freely given. If a data subject has no real choice, feels compelled to consent, or will endure negative consequences if they do not consent, then consent will not be valid. Consent must be indicated by a positive action. This means that you cannot use pre-ticked opt-in boxes or other types of default consent. Information must be provided prior to obtaining consent to allow data subjects to make informed decisions. Consent must also be specific and granular, and you should obtain separate consent for each relevant processing operation. Vague or blanket consent will unlikely be valid. Additionally, consent must be kept separate from other terms and conditions and must be easy to withdraw, without disadvantaging the data subjects. Performance of a contract. If an individual's personal data needs to be processed to deliver a contractual service to them, or because they have asked for something to be done before entering into a contract, then you should consider contract as your lawful basis. For example, where a quote is requested, an organization may need to process certain personal data in order to prepare this. Compliance with a legal obligation. You can rely on this basis if you need to process an individual's personal data to comply with the law or a statutory obligation. Note that you cannot rely on this lawful basis if you have discretion over whether to process the personal data or if there is another reasonable way to comply. Vital interests. This lawful basis applies in circumstances where an individual's personal data needs to be processed to protect someone's life. It is likely to be particularly relevant in emergency medical cases. Given that the protection of vital interests is likely to arise in the context of health data, which is considered a special category of data, you will also need to identify a condition for processing under Article 9 of the Gibraltar GDPR. Public task. Public task considerations are most relevant to public authorities, but the lawful basis can also apply to any organization that exercises official authority or carries out tasks in the public interest. To rely on this basis, you must be able to demonstrate that the processing is necessary for that purpose. If you could reasonably perform your tasks or exercise your powers in a less intrusive way, without collecting the data in question, this lawful basis will not apply. Legitimate interests. Often regarded as the most flexible lawful basis for processing. However, you must not assume it will always be the most appropriate. This basis involves some judgment, and a 3-part balancing test called a legitimate interests assessment, which involves identifying a legitimate interest, showing that the processing is necessary to achieve it, and balancing this against the individual's interests, rights, and freedoms. Special category data is defined in Article 9 of the Gibraltar GDPR and includes sensitive information such as racial and ethnic origin or health data. To lawfully process special category data, you must identify a lawful basis under Article 6 of the Gibraltar GDPR and a separate condition for processing under Article 9 of the Gibraltar GDPR. Similarly, Article 10 of the Gibraltar GDPR sets out separate safeguards for personal data classed as criminal offence data. This would concern personal data of offenders or suspected offenders in the context of criminal activity, allegations, investigations, and proceedings. In this regard, a lawful basis under Article 6 of the Gibraltar GDPR and a separate condition for processing under Article 10 of the Gibraltar GDPR must be identified. Article 9 and 10 of the Gibraltar GDPR may refer you to the Data Protection Act 2004, which may require you to meet additional conditions and safeguards for the processing of this type of data. For more information, please visit the SME Resource Hub or Guidance section on our website.